Here's a court case that Virginia don't want you to know. Butt versus Rachel, 1814. A Native American Indian brought into Virginia since 1691 could not lawfully be held in slavery. Notwithstanding, such Indian was a slave in the country from which she came from. At the trial, the defendant tendered a bill of exception which was signed and sealed, stating that the plaintiffs claimed their freedom upon the ground of their being descendants of Papoose, a Native American female Indian, who was brought into Virginia about the year 1747, and moved the court to instruct the jury that no Native American Indian brought into Virginia since the year 1691 could under any circumstances be made a slave, which instruction the court did give. Whereupon the defendant, who claimed to hold the plaintiffs as slaves upon the grounds that though they were alleged to be descendants of the said Papoose, a Native American Indian, the said Indian was alleged to be a slave and held as such in the island of Jamaica by the wife of Mr. Ivy, and brought by the said Ivy into Virginia as a slave about the year 1747, moved the court to instruct the jury that a Native American Indian held in Jamaica as a slave under the laws of that island and imported into Virginia by the proprietor in the year 1746 or 1747 might be lawfully held as a slave in Virginia. In the 2D volume of Henning Statutes at Large are several acts showing the Indians might be slaves, for the persons who could lawfully be held as such are not described as Negroes only, but as any persons not Christians. The Indian woman Papoose is declared by the Bill of Exceptions to have been a Native American Indian carried from this country to Jamaica and brought hither from that island. We had no right to declare Papoose free in Jamaica, but we had the right to say that when brought into our territory, she should be free. Now let's tie all this together. Remember the new laws of 1542 by Spain? You know, in that law, they could not tell the difference between American Indian and the African. Here it is. Influence of Spanish laws and justifications. Spanish colonial laws such as the new laws of 1542 were established by the Spanish crown to prevent the enslavement of indigenous people after recognizing their rights to some degree. However, these laws were largely circumvented in practice. To avoid penalties associated with indigenous slavery, traders mislabeled indigenous peoples as Africans or as originating from regions where the Spanish crown had allowed the enslavement of people. So there you go, you see it. They were confusing Africans with indigenous people from the new laws of 1542. So let's just say this. Let's just say that there was an indigenous population in Mexico. They shipped that same indigenous population to the Caribbeans, and those same people went to North Carolina, just like Papoose. Papoose was originally from North Carolina, her bloodline, and they were shipped to Jamaica. Then she returned back, just like in that case. So fast forward, you got an influx of people coming to North America that was mislabeled as Africans, when in reality, it was Indians all along, just like Papoose. If you want part 2, give me 200 to 300 likes on this video, and I'll make part 2. In part 2, I'll show you who exactly those Indians was in the Caribbeans and how they got there, and who were they, and who are their descendants today.